Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Catholic Charities Bureau Incorporated v. Wisconsin Labor and Industry Review Commission. In this case, the court considered this issue. Does a state violate the First Amendment's religion clauses by denying a religious organization an otherwise available tax exemption because the organization does not meet the state's criteria for religious behavior? The case was decided on June 5, 2025. In a unanimous decision on June 5, 2025, the U.S. Supreme Court ruled in Catholic Charities Bureau Incorporated v. Wisconsin Labor and Industry Review Commission, affirming that the Catholic Charities Bureau, CCB, is entitled to an exemption from Wisconsin's unemployment insurance tax. The court held that the state's refusal to grant this exemption violated the First Amendment by discriminating against religious organizations that do not engage in overt religious activities. Justice Sonia Sotomayor authored the opinion, emphasizing that Wisconsin's approach improperly favored organizations that proselytize or serve only co-religionists, thereby violating the principle of government neutrality in religious matters. The court noted that CCB's mission, while providing secular services such as housing and job training, is rooted in Catholic teachings and operates under the auspices of the Catholic Diocese of Superior. The decision underscores that religious organizations cannot be denied exemptions based solely on the secular nature of their services. This ruling aligns with the court's broader trend of expanding religious liberties and may have implications for other religiously affiliated organizations seeking similar exemptions. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. Wisconsin, like many other states, exempts certain religious organizations from paying taxes into the state's unemployment compensation system. One such exemption covers nonprofits operated primarily for religious purposes and controlled, supervised, or principally supported by a church. Petitioners, Catholic Charities Bureau Incorporated, and four of the entities that it operates, claim that they qualify for the exemption as religious organizations controlled by the Roman Catholic Diocese of Superior, Wisconsin. The Wisconsin Supreme Court disagreed, holding that petitioners are not operated primarily for religious purposes because they neither engage in proselytization nor serve only Catholics in their charitable work. The question here is whether Section 108.0215H2, as applied to petitioners by the Wisconsin Supreme Court, violates the First Amendment. The court holds that it does. The First Amendment mandates government neutrality between religions and subjects any state-sponsored denominational preference to strict scrutiny. The Wisconsin Supreme Court's application of Section 108.0215H2 imposed a denominational preference by differentiating between religions based on theological lines. Because the law's application does not survive strict scrutiny, it cannot stand. Wisconsin has long operated an unemployment compensation program that seeks to mitigate and more fairly distribute the economic burdens resulting from unemployment. Wisconsin Stat. Section 108.012. To achieve that goal, Wisconsin law requires most employers to make regular contributions to the state's unemployment fund through payroll taxes. Nonprofit employers may choose between contributing to that fund and reimbursing the state for benefits paid to their laid-off employees. Wisconsin's regime contains an exemption for religious employers. The exemption applies to any church or convention or association of churches, without further qualification, and to services provided by a duly ordained, commissioned or licensed minister of a church in the exercise of his or her ministry, or by a member of a religious order in the exercise of duties required by such order. As relevant here, the exemption also covers non-profit organizations operated, supervised, controlled, or principally supported by a church or convention or association of churches, but only if they are operated primarily for religious purposes. Wisconsin is not alone in exempting religious organizations from unemployment compensation taxes. In the Federal Unemployment Tax Act, Congress included a textually parallel religious employer exemption. Since Congress enacted that law in 1970, over 40 states have adopted similar exemptions. Catholic Charities Bureau Incorporated Bureau is a non-profit organization that serves as the social ministry arm of the Roman Catholic Diocese of Superior, Wisconsin. The Bureau's stated mission is to carry on the redeeming work of our Lord. In aid of that mission, the Bureau provides services to the poor and disadvantaged and seeks to be an effective sign of the charity of Christ. It does not distinguish on the basis of race, sex, or religion in reference to clients served, staff employed and board members appointed. The Bureau oversees several separately incorporated entities, including four that, together with the Bureau, are the petitioners here: Barron County Development Services Incorporated, Black River Industries Incorporated, Diversified Services Incorporated, and Headwaters Incorporated. These entities provide a range of charitable services to local communities across Wisconsin. Barron County Development Services, for instance, helps individuals with disabilities secure employment. Black River Industries provides daily living services to Wisconsinites with developmental or mental health disabilities, among other charitable services. The Roman Catholic Diocese of Superior exercises control over both the Bureau and its sub-entities. The bishop of the diocese serves as the Bureau's president and appoints its membership, which in turn oversees the Bureau to ensure that it fulfills its mission in compliance with the principles of Catholic social teaching. The Bureau's executive director, who need not be a Catholic priest, supervises the operations of each sub-entity. Employees of the Bureau and its sub-entities are not required to ascribe to any particular religious faith, and the same is true for the recipients of their charitable services. Participants in petitioners' charitable programs do not receive religious training or orientation, and neither the Bureau nor its sub-entities tries to inculcate participants with the Catholic faith. That rule, petitioners explain, reflects religious doctrine prohibiting Catholic bodies from misusing works of charity for purposes of proselytism. According to petitioners, Catholic teachings distinguish between evangelization, which involves sharing one's faith, and proselytization, which seeks to influence or coerce others into accepting one's religious views. The former is permitted, and the latter is not, petitioners say. In 2016, petitioners sought from the Wisconsin Department of Workforce Development a determination that they qualified for the religious employer exemption set forth in Wisconsin Stat. Section 108.0215H2. The department denied their request. It acknowledged that petitioners are supervised and controlled by the Roman Catholic Church, thereby satisfying one of the two criteria for the exemption. The department determined, however, that petitioners are not operated primarily for religious purposes within the meaning of the statute. Petitioners appealed, and an administrative law judge, ALJ, reversed the department's ruling. In the years that followed, petitioners received a series of alternating wins and losses as the parties appealed up through the state administrative and judicial systems. The Wisconsin Labor and Industry Review Commission reversed the ALJ's decision and reinstated the department's denials of petitioners' exemption requests. After petitioners sought judicial review in state court, the state trial court overrode the commission, holding that petitioners are entitled to the exemption. The State Court of Appeals, however, subsequently reversed. It reasoned that petitioners are not operated primarily for religious purposes because petitioners' provision of charitable social services are neither inherently or primarily religious activities. The Wisconsin Supreme Court affirmed. The court began by recognizing, as the lower courts had, that petitioners are without question operated, supervised, controlled, or principally supported by the Diocese of Superior. The dispositive question, then, was whether petitioners are operated primarily for religious purposes. The court interpreted that statutory phrase to require judicial inquiry into not only an organization's motivations but also its activities. To determine whether an organization's activities are primarily religious in nature, the court held, courts should focus on whether an organization participated in worship services, religious outreach, ceremony, or religious education. According to the court, that analysis would identify typical activities of an organization operated for religious purposes, while avoiding any subjective inquiry with respect to religious truth. Applying that standard, the court held that petitioners' activities are secular in nature, not religious. Petitioners neither attempt to imbue program participants with the Catholic faith nor supply any religious materials to program participants or employees, the court observed. Both employment with the organizations and services offered by the organizations are open to all participants regardless of religion, and the charitable services offered by the sub-entities could be provided by organizations of either religious or secular motivations. Based on that record, the court held that petitioners are not operated primarily for religious purposes within the meaning of Wisconsin Stat. Section 108.0215H2. The court then addressed petitioners' argument that its interpretation of Section 108.0215H2 violated the First Amendment's religion clauses. The court first held that its interpretation did not transgress church autonomy principles, because the exemption neither regulates internal church governance nor mandates any activity. The court also determined that there was no risk of excessive government entanglement with religion because Wisconsin's exemption does not ask whether petitioners' activities are consistent or inconsistent with Catholic doctrine. Finally, the court rejected petitioners' argument that its interpretation contravened First Amendment principles of neutrality among religions by favoring religious groups that require those they serve to adhere to the faith of that group or be subject to proselytization. This argument failed, the court said, because petitioners had not demonstrated that the statute imposes a constitutionally significant burden on their religious practice in the first place. Justice Rebecca Grassel Bradley authored a dissent, which Chief Justice Ziegler joined and Justice Hagedorn joined in part. Justice Bradley would have held that a non-profit is operated primarily for religious purposes, Section 108.0215H2, when its motivations are religious, irrespective of the nature of its activities. The majority's contrary approach, the dissent warned, engages in religious discrimination and entangles the state with religion in violation of the First Amendment. While Justice Bradley recognized that the application of secular criteria that leads to disparate treatment of religions is not religious discrimination, she reasoned that the majority's approach necessarily and explicitly discriminates among certain religious faiths and religious practices. It did so as applied to petitioners, Justice Bradley explained, by declaring them ineligible for the exemption based on explicitly religious criteria, including their adherence to Catholic teachings forbidding proselytization when conducting charitable acts. That denominational discrimination, according to Justice Bradley, triggered strict scrutiny, which the state could not satisfy. Justice Hagedorn dissented separately, noting his agreement with Justice Bradley's construction of the statute. We granted certiorari to decide whether the Wisconsin Supreme Court's interpretation of Section 108.0215H2, as applied to petitioners, violates the First Amendment. The clearest command of the Establishment Clause is that the government may not officially prefer one religious denomination over another. In Larson v. Valente, we set a demanding standard for the government to justify differential treatment across religions on denominational lines. This principle of denominational neutrality bars states from passing laws that aid or oppose particular religions, as stated in Epperson v. Arkansas, or interfere in the competition between sects, as noted in Zorak v. Clausen. The Establishment Clause's prohibition of denominational preferences is inextricably connected with the continuing vitality of the Free Exercise Clause too. In Larson, we emphasize that the fullest realization of true religious liberty requires that government refrain from favoritism among sects. Government actions that favor certain religions, the court has warned, convey to members of other faiths that they are outsiders, not full members of the political community, as observed in Santa Fe Independent School Dist. v. Doe. To guard against that serious harm, in Larson v. Valente, we held that when a state law establishes a denominational preference, courts must treat the law as suspect and apply strict scrutiny in adjudging its constitutionality. The government bears the burden to show that the relevant law, or application thereof, is closely fitted to further a compelling governmental interest. A law that differentiates between religions along theological lines is textbook denominational discrimination. Take, for instance, a law that treats a religious service of Jehovah's Witnesses differently than a religious service of other sects because the former is less ritualistic, more unorthodox, and less formal, as discussed in Fowler v. Rhode Island. Or consider an exemption that applies only to religious organizations that perform baptisms, engage in monotheistic worship, or hold services on Sunday. Such laws establish a preference for certain religions based on the content of their religious doctrine, namely, how they worship, hold services, or initiate members and whether they engage in those practices at all. Such official differentiation on theological lines is fundamentally foreign to our constitutional order, for the law knows no heresy, and is committed to the support of no dogma, as stated in Watson v. Jones. This case involves that paradigmatic form of denominational discrimination. In determining whether petitioners qualified for the tax exemption under Section 108.0215H2, the Wisconsin Supreme Court acknowledged that petitioners are controlled by a church, the Roman Catholic Diocese of Superior, thereby satisfying one of the exemption's two criteria. The court's inquiry instead turned on whether petitioners are operated primarily for religious purposes. On that criterion, the court recognized that petitioners' charitable works are religiously motivated. The court nevertheless deemed petitioners ineligible for the exemption under Section 108.0215H2, because they do not attempt to imbue program participants with the Catholic faith, supply any religious materials to program participants or employees, or limit their charitable services to members of the Catholic Church. Put simply, petitioners could qualify for the exemption while providing their current charitable services if they engaged in proselytization or limited their services to fellow Catholics. Petitioners' Catholic faith, however, bars them from satisfying those criteria. Catholic teaching, petitioners say, forbids misusing works of charity for purposes of proselytism. It also requires provision of charitable services without making distinctions by race, sex, or religion. Many religions apparently impose similar rules prohibiting proselytization or religious differentiation in the provision of charitable services. Others seemingly have adopted a contrary approach. Wisconsin's exemption, as interpreted by its Supreme Court, thus grants a denominational preference by explicitly differentiating between religions based on theological practices. Indeed, petitioners' eligibility for the exemption ultimately turns on inherently religious choices, namely, whether to proselytize or serve only co-religionists, not secular criteria that happen to have a disparate impact upon different religious organizations, as clarified in Larson. Much like a law exempting only those religious organizations that perform baptisms or worship on Sundays, an exemption that requires proselytization or exclusive service of co-religionists establishes a preference for certain religions based on the commands of their religious doctrine. In short, as applied to petitioners by the Wisconsin Supreme Court, Wisconsin, Stat. Section 108.0215H2 imposes a denominational preference by differentiating between religions based on theological choices. The state does not dispute that the government may not prefer one religion over another. Instead, the state argues that, when it comes to religious accommodations afforded by the government, courts should ask whether the accommodation's eligibility criteria are the product of invidious discrimination to determine if strict scrutiny applies. In Gillette v. United States, the state contends, this court supported this rule. As the state would have it, Gillette stands for the premise that whenever a religious accommodations line serves considerations of a pragmatic nature having nothing to do with a design to foster or favor any sect, religion, or cluster of religions, the Establishment Clause is not offended. The inquiry set forth in Gillette, however, is inapposite. There, this court rejected an Establishment Clause challenge to a provision of the Military Selective Service Act of 1967, which afforded a conscientious objector status to any person who, by reason of religious training and belief, was conscientiously opposed to participation in war in any form. Importantly, that exemption focused on individual conscientious belief, not on sectarian affiliation. Conscientious objector status was thus available on an equal basis to members of all religions under the Military Selective Service Act, as this court later explained in Larson. On its face, the statute simply did not discriminate on the basis of religious affiliation. The same is not true here. The Wisconsin Supreme Court's interpretation of Section 108.02H, 15.2, facially differentiates among religions based on theological choices. After all, an exemption provided only to organizations that engage in proselytization or serve only co-religionists is not, on its face, available on an equal basis to all denominations. That type of explicit distinction between religious practices is what this court has deemed subject to strict scrutiny, including in the context of religious exemptions. Next, the state disputes the premise that petitioners were denied coverage because they do not proselytize or serve only Catholics in the course of performing charitable work. The state insists that, instead, the Wisconsin Supreme Court excluded petitioners because they had identified no distinctively religious activity that would create difficulty in resolving unemployment disputes. When pressed at argument as to what would qualify as such distinctively religious activity in the context of providing charitable services, however, the state clarified that it meant activities that express and inculcate religious doctrine, worship, proselytization, religious education. That understanding of the Wisconsin Supreme Court's ruling, even if assumed correct, cannot save the statute from strict scrutiny. Decisions about whether to express and inculcate religious doctrine through worship, proselytization, or religious education when performing charitable work are, again, fundamentally theological choices driven by the content of different religious doctrines. A statute that excludes religious organizations from an accommodation on such grounds facially favors some denominations over others. Because Section 108.0215H2 grants denominational preferences of the sort consistently and firmly deprecated in our precedents, it must be invalidated unless it is justified by a compelling governmental interest and is closely fitted to further that interest. The state bears the burden of clearing that high bar, and it has failed to do so here. Wisconsin justifies its law by reference to two principal interests. First, it argues that the law serves a compelling state interest in ensuring unemployment coverage for its citizens. Yet the state fails to explain how the theological lines drawn by Section 108.0215H2 are narrowly tailored to advance that asserted interest, particularly as applied to petitioners. Indeed, petitioners operate their own unemployment compensation system for employees, which provides benefits largely equivalent to the state system. Furthermore, Wisconsin does not suggest that organizations like Catholic Charities, which decline to proselytize and choose to serve all comers, are more likely to leave their employees without unemployment benefits. Nor could it. The record is devoid of such evidence. The distinctions drawn by Wisconsin's regime, moreover, are vastly under-inclusive when it comes to ensuring unemployment coverage for its citizens. Wisconsin exempts over 40 forms of employment from its unemployment compensation program. Notably, those exemptions cover religious entities that provide charitable services in a similar manner to petitioners, that is, without proselytizing or denominational differentiation, but are exempt because the work is done directly by the church itself or its ministers, rather than by a separate non-profit organization controlled by the church. That under-inclusiveness leaves appreciable damage to the state's supposedly vital interest unprohibited, and therefore belies the state's claim of narrow tailoring, as noted in Reed v. Town of Gilbert. Second, The state argues that the Wisconsin Supreme Court's interpretation of Section 108.0215H2 is narrowly tailored to avoid entangling the state with employment decisions touching on religious faith and doctrine. When an organization's employees express and inculcate religious doctrine through worship, proselytization, and religious education, the state explains, misconduct disputes could often force the state to decide whether employees complied with religious doctrine. Yet the state again fails to demonstrate that Section 108.0215H2 is closely fitted to further that anti-entanglement interest. To the extent the state seeks to avoid opining on employee compliance with religious teachings, it does not explain why it declined to craft an exemption limited to employees who are in fact tasked with inculcating religious doctrine. Instead, the exemption here functions at an organizational level, covering both the janitor and the priest in equal measure. That over-inclusiveness pervades Wisconsin's exemption regime more broadly, too. Recall that Wisconsin exempts from its unemployment compensation system all churches or conventions or associations of churches without differentiating between employees actually involved in religious works, for whom the anti-entanglement concern is relevant, and other staff. The state itself concedes, as it must, that this regime contains an element of over-inclusivity. At bottom, then, the poor fit between the state's asserted anti-entanglement concern and the line it has drawn among religious organizations cannot be described as narrow tailoring. The state has thus failed to carry its burden under strict scrutiny. It is fundamental to our constitutional order that the government maintain neutrality between religion and religion. There may be hard calls to make in policing that rule, but this is not one. When the government distinguishes among religions based on theological differences in their provision of services, it imposes a denominational preference that must satisfy the highest level of judicial scrutiny. Because Wisconsin has transgressed that principle without the tailoring necessary to survive such scrutiny, the judgment of the Wisconsin Supreme Court is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. It is so ordered. Justice Thomas, concurring. A nonprofit organization is entitled to an exemption from Wisconsin's unemployment insurance tax on employers if it is controlled by a church and operated primarily for religious purposes. The Wisconsin Supreme Court concluded that Catholic Charities Bureau, Catholic Charities, and its sub-entities are not such organizations, reasoning in two steps. First, the court held that the relevant organization is Catholic Charities and each of its sub-entities, not the broader Catholic Diocese of Superior of which it is a part. Second, it held that the purposes of Catholic Charities and its sub-entities are primarily secular, not religious. The court concludes that the latter holding of the Wisconsin Supreme Court unconstitutionally discriminates against Catholic Charities and its sub-entities. I agree and join the court's opinion in full. I write separately because, in my view, the Wisconsin Supreme Court's first holding was also wrong. The First Amendment's guarantee of church autonomy gives religious institutions the right to define their internal governance structures without state interference. Religious institutions may create different corporate entities to help manage their temporal affairs, but those entities do not define the broader religious institution's internal structure. Here, although Catholic Charities and its sub-entities are separately incorporated from the Diocese of Superior, they are, as a matter of church law, simply an arm of the diocese. The First Amendment guarantees to religious institutions broad autonomy to conduct their internal affairs and govern themselves. This guarantee, which we have called the Church Autonomy Doctrine, provides that a religious institution is not defined by the corporate entities it chooses to form. The religion clauses of the First Amendment prescribe laws respecting an establishment of religion, or prohibiting the free exercise thereof. Among other protections, these clauses guarantee the right to organize voluntary religious associations, as recognized in Watson v. Jones, and to allow these associations to decide for themselves, free from state interference, matters of church government as well as those of faith and doctrine, as stated in Kedroff v. St. Nicholas Cathedral of Russian Orthodox Church in North America. For instance, in Our Lady of Guadalupe's School v. Morrissey Baru, we held that courts are bound to stay out of employment disputes involving those holding certain important positions with churches and other religious institutions. And, where resolution of a property dispute turns on the internal law of a hierarchically structured church, such as who is the properly appointed pastor of a congregation, courts must defer to the decisions of the highest ecclesiastical tribunal within the Church, as explained in Serbian Eastern Orthodox Diocese for United States and Canada v. Milivojevic. The Religion Clause's special protection for the autonomy of religious institutions derives from at least three sources. First is the right of association. In Roberts v. United States J.C.'s, this court has long understood as implicit in the right to engage in activities protected by the First Amendment a corresponding right to associate with others. As with other voluntary associations, those who unite themselves to a religious body do so with an implied consent to its internal system of government, and are bound to submit to it, as noted in Watson, 13 Wall. And, since the text of the First Amendment gives special solicitude to the rights of religious organizations, they must enjoy a greater right to control their own affairs than that enjoyed by other groups, as affirmed in Hosanna Tabor Evangelical Lutheran Church and School VEOC. Second is the reality that matters of religious faith and doctrine are closely linked to matters of church government. In Our Lady, we recognize that who serves as a church's minister, for instance, determines whether the preaching, teaching, and counseling a congregation receives conforms to the faith that it professes. And, the polity of a religious institution is often itself a matter of faith. In the Catholic Church, for instance, the leadership of the Pope over the Church is essential, because it is an article of faith that Jesus Christ personally established the office of Pope. Third is the understanding that church and state are two rightful authorities, each supreme in its own sphere. This concept has deep roots in the history of Western civilization. Jesus famously said to render unto Caesar the things which are Caesar's, and unto God the things that are God's. Matthew 22:21. From antiquity onward, many Christians have interpreted this statement to mean that church and state are distinct, and that each has a legitimate claim to authority within its sphere. In Huntsman v. Corporation of President of Church of Jesus Christ of Latter-day Saints, Judge Bumate's concurrence traced this principle, and other sources have elaborated on the historical development of the doctrine of separate spheres of authority for church and state. Pre-founding English law accordingly distinguished between temporal matters subject to civil courts jurisdiction and spiritual matters subject to ecclesiastical jurisdiction, as discussed in Judge Oldham's dissent in McCraney v. Northam, Mission B.D. of Southern Baptist Convention Incorporated. The First Amendment was adopted against this background of distinct spheres for secular and religious authorities, as noted in Hosanna Tabor. In arguing for religious freedom for Baptists, for example, James Madison appealed to the notion of independent spiritual and earthly authorities. According to Madison, man's duty towards the Creator is precedent, both in order of time and in degree of obligation, to the claims of civil society. Thus, religion is wholly exempt from civil society's cognizance. In a similar vein, early American decisions justified protections for church autonomy in part based on the need to respect religious institutions' legitimate and distinct sphere of authority. In Watson, we held that the civil courts exercise no jurisdiction over matters of ecclesiastical government because doing so would deprive religious bodies of the right of construing their own church laws. Other early cases, such as Chase v. Cheney and Harmon v. Dreher, similarly emphasize the separation of spiritual and temporal jurisdictions. The church autonomy doctrine has important ramifications for the incorporation of religious institutions. Establishing corporate entities is essential for religious institutions to manage their temporal affairs. But, the doctrine forbids treating religious institutions as nothing more than the secular organizations themselves. Religious organizations do not exist apart from the secular world. They need to buy and sell property. They need to hire and pay staff. They need to form contracts and file lawsuits. They need their property arrangements to persist when personnel changes occur, and they need their property to remain secure when individual members of the institution become insolvent. These matters make the formation of corporate entities essential for many religious organizations. At the same time, the church autonomy doctrine forbids treating religious institutions as nothing more than the statutory entities they have formed. In Trustees of Dartmouth College v. Woodward, we recognize that a corporation is a mere creature of law that generally possesses only those properties which the charter of its creation confers upon it. And, state law has a great deal to say about how a corporation must be structured. But, under the church autonomy doctrine, religious institutions are a parallel authority to the state, not a creature of state law. And, the state has no legitimate role in defining the structure of its polity. To conclude that a religious organization has no authority outside its corporate form would be in effect to decide that our religious liberties are dependent on the will of the legislature, and not guaranteed by the Constitution, as stated in Burrs ex Res v. Smith. Instead, courts have long recognized that while a legal entity may represent the church or other body of believers, the entity alone is not the church, it is only a part of the entire religious organization. A religious corporation thus possesses a dual personality. It is at once a corporation defined by state law and a part of a broader, unincorporated religious institution. In Watson, the nominal title holders and custodians of the church property at issue were a body corporate created by an act of the Kentucky legislature. That corporation, we recognized, was not itself the church, but merely an entity under the control of the church session, an ecclesiastical governing authority, composed of the ruling elders and pastor. Thus, the Constitution, usages, and laws of the church, not Kentucky law, controlled the outcome of the dispute. In Hosanna Tabor, we recognize that the original understanding of religious autonomy principles is reflected in early post-ratification practice. Here, that confirms that religious organizations are more than the entities that they form, and that conflating the two undermines their First Amendment rights. Before independence, corporate law provided the civil government with a mechanism to interfere in ecclesiastical affairs. Religious institutions had a particularly acute need to incorporate during that period because they could not hold property in their own right without such status. But incorporating was not easy. In most colonies, a religious group had to petition the government for a special charter of incorporation, and the government frequently denied the requests of certain religious denominations. Following the Revolution, New York took a different path, enacting a statute to allow churches to incorporate without a special charter. The state grounded its new approach in respect for church autonomy. Invoking the Free Exercise Clause of the state's 1777 Constitution, the preamble to the 1784 Act condemned the legislature's former practice of providing for illiberal and partial distributions of charters of incorporation to religious societies. The 1784 Act liberalized the incorporation process to enable every religious denomination to provide for the decent and honorable support of divine worship. The 1784 Act authorized members of a church to elect trustees who, upon registering with a court, would become a body corporate able to hold property, exist perpetually, and sue in court. But, although this body could be entrusted with the management, care and disposition of the temporalities of the church, the Act made clear that the corporate body was not the church itself. The Act did not purport to name the trustees the leaders of the church, but took for granted that each church would be headed by a minister. And the Act specifically warranted that its provisions did not in the least alter or change the religious constitutions or governments of any churches. The 1784 Act soon became a model for the nation at large. With a handful of exceptions, analogous statutes were adopted in every American state during the antebellum era. In Tourette v. Taylor, this court approved this trend, holding that it neither established religion nor restrained free exercise for a legislature to enact laws more effectually to enable all sects to accomplish the great objects of religion by giving them corporate rights for the management of their property. Thus, like New York and the states following its approach, this court too framed incorporation as a way to empower religious institutions, not to define them or alter their polity. In contrast, when Congress in 1811 attempted to use the corporate form to define a church's internal form of government, President James Madison raised a decisive constitutional objection. In Hosanna Tabor, we recounted that Congress had passed a bill incorporating the Protestant Episcopal Church in the town of Alexandria in what was then the District of Columbia. President Madison vetoed the bill, finding that it violated the First Amendment because it did not respect the essential distinction between civil and religious functions. Madison further explained, "The bill enacts into and establishes by law sundry rules and proceedings relative purely to the organization and polity of the Church incorporated, and comprehending even the election and removal of the minister of the same, so that no change could be made therein by the particular society, or by the general church of which it is a member, and whose authority it recognizes." As a matter of church law, Catholic Charities and its sub-entities are an arm of the Diocese of Superior, and thus, for religious purposes, are not distinct organizations. But, when determining whether Catholic Charities was a religious organization entitled to a tax exemption, the Wisconsin Supreme Court nevertheless relied on Catholic Charities' separate corporate charter to treat it as an entity entirely distinct and separate from the diocese. That holding contravened the church autonomy doctrine. The Catholic Church is a single worldwide religious institution. The Church is headed by the Pope. Catholics believe that the Pope is the successor of St. Peter, the apostle chosen by Jesus to lead the Church. The Church is divided into dioceses. A diocese generally consists of all the faithful living within a definite territory, who together constitute a particular church within the universal church. Each diocese is entrusted to a bishop for him to shepherd. The bishop exercises legislative, executive, and judicial power over his diocese. This structure of the Church is a matter of faith, not mere administrative convenience. Catholics believe that in naming the apostles, Jesus personally established the office of bishop and willed that the bishops should be shepherds in his church right to the end of the world. In the Code of Canon Law, Canon 375, Section 1, it is stated that bishops, by divine institution, succeed to the place of the apostles through the Holy Spirit who has been given to them. The Church understands itself to have a threefold religious mission: proclaiming the Word of God, celebrating the sacraments, and exercising the ministry of charity. These duties presuppose each other and are inseparable. The Church therefore cannot neglect the service of charity, that is, care for widows and orphans, prisoners, and the sick and needy of every kind, any more than she can neglect the sacraments and the Word. In keeping with the Church's hierarchical structure, the bishops have primary responsibility for carrying out the service of charity at the local level. In particular, bishops are bound under canon law to establish within their territories organizations to carry out charitable works in the name of the Church subject to their supervision and control. In the United States, these organizations are known as Catholic Charities. The works of these organizations are considered acts of the Church itself. The Diocese of Superior covers the northwest corner of Wisconsin. Catholic Charities is the social ministry arm of the diocese. In keeping with Catholic principles, the Bishop of Superior serves as the head of Catholic Charities and exercises plenary authority over it. Catholic Charities is organized under state law as a non-profit corporation governed by 3 members. The first member is the bishop, who serves as the organization's president. The second member is the diocese's vicar general, who is the vice president. Under canon law, the vicar general is a priest chosen by the bishop to assist him in the governance of the whole diocese. The third member is the organization's executive director, who need not be a priest. The bishop appoints both the vicar general and the executive director, who serve at his pleasure. This structure gives the bishop control over both Catholic Charities and its separately incorporated subentities, up to and including the power to dissolve them at will. The Wisconsin Supreme Court disregarded this structure of Catholic Charities and its subentities in adjudicating the case below. The court acknowledged Catholic Charities' status as an arm of the Diocese of Superior subject to the bishop's control. It nonetheless viewed Catholic Charities and its subentities as distinct, non-religious organizations merely because they are separately incorporated. Wisconsin imposes a tax on employers to cover the cost of state-provided unemployment benefits. The tax covers most employers in the state, but an exception applies if the employer is a church or an organization controlled by a church that is operated primarily for religious purposes. Catholic Charities and 4 of its subentities sought an exemption under the latter category. The Wisconsin Supreme Court held that the organizations were not operated for religious purposes, and thus that excluding Catholic Charities and its subentities from the exemption did not violate the religion clauses of the First Amendment. In construing the scope of the exemption, the court began with the threshold question of whose purposes we must examine in our analysis, those of the diocese or those of Catholic Charities and its subentities. The court treated this question as one of ordinary statutory interpretation, determining that the plain language of the statute required looking to the individual corporate entity's purpose, not the purpose of the church that operates or controls it. Catholic Charities objected that examining itself and its sub-entities as corporations separate from the diocese violates the First Amendment's guarantee of church autonomy by dividing up religious bodies according to secular principles. The Wisconsin Supreme Court disagreed. It acknowledged that, under the First Amendment, matters of ecclesiastical governance belong to the church alone. But, it insisted that the exemption simply defines what employment is for purposes of unemployment insurance without reference to any religious principles or any attempt to control internal operations. The Wisconsin Supreme Court's resolution of this threshold question was outcome determinative. The court recognized that the diocese's purpose is religious by nature. In contrast, the court found that Catholic Charities and its sub-entities' purposes are primarily charitable and secular. As Wisconsin concedes, had the court resolved the threshold question of whose purpose controls the other way, it would have found that Catholic Charities and its sub-entities would qualify for the church exemption. By failing to defer to the Bishop of Superior's religious view that Catholic Charities and its sub-entities are an arm of the diocese, the Wisconsin Supreme Court violated the church autonomy doctrine. Wisconsin's unemployment tax implicates the church autonomy doctrine. The statute on its face treats religious institutions differently from secular institutions. If an employer is a church or an organization controlled by a church that is operated primarily for religious purposes, it is exempt from the tax. If not, the tax applies. The statute makes this distinction precisely to preserve the religious autonomy of the exempted organizations. The statute thus does not simply impose neutral and generally applicable burdens that do not affect internal governance. It requires civil courts to classify employers as religious or not, and to treat them differently based on that classification. But, the church autonomy doctrine leaves it to religious institutions to define their internal structure for themselves. In Kedroff, we held that religious institutions must be free to decide matters of church government. When deciding whether an employer qualifies as a religious institution, a civil court must accept the employer's understanding of its internal structure, just as it must accept the employer's understanding of its religious beliefs generally. In Milivojevic, we emphasize that allowing civil courts to probe deeply into the allocation of power within a hierarchical church to decide religious law governing church polity would violate the First Amendment. Here, there is no dispute that, as a matter of church governance, the Bishop of Superior, the head of both the Diocese of Superior and Catholic Charities, considers Catholic Charities and its sub-entities to be an arm of the diocese rather than a distinct organization. In other words, Catholic Charities and its sub-entities are corporate entities that the diocese has created to carry out its religious mission. It is therefore dispositive that, as the state concedes, the diocese qualifies for the religious employer exemption. As an arm of the diocese from the bishop's perspective, Catholic Charities and its sub-entities must qualify as well, regardless of whether their activities, considered in isolation, would qualify as religious. In holding otherwise, the Wisconsin Supreme Court entirely disregarded the bishop's religious judgment, relying instead on the fact that Catholic Charities and its sub-entities are organized as separate corporations apart from the Church itself. The court thus made the error of treating a religious institution as nothing more than its corporate entities. Wisconsin defends its Supreme Court's judgment, arguing that the church autonomy doctrine is inapposite because the state has not compelled the diocese to alter its structure. In Wisconsin's view, the state has only imposed a minor tax to which the diocese has no conscience objection. But in Carson v. Macon, we held that the First Amendment protects against indirect coercion or penalties on the free exercise of religion, not just outright prohibitions. The exclusion of religious observers from otherwise available public benefits is a cognizable free exercise burden. This principle applies with full force to the church autonomy doctrine. The doctrine rests on the premise that civil courts must exercise no jurisdiction over subject matters that are ecclesiastical in its character, as stated in Watson. Regardless of whether the religious institution's injury is direct coercion or the withholding of a benefit, essentially religious controversies are an inappropriate subject matter for civil courts to decide, as emphasized in Milivojevic. The court correctly holds that Catholic Charities and its sub-entities have suffered unconstitutional religious discrimination even on the assumption that those entities should be considered in isolation. I would reverse for an additional reason, that the Wisconsin Supreme Court violated the church autonomy doctrine. However incorporated, Catholic Charities and its sub-entities are, from a religious perspective, a mere arm of the Diocese of Superior. The Wisconsin Supreme Court should have deferred to that understanding, and its failure to do so amounted to an unlawful attempt by the state to redefine the diocese's internal governance. Justice Jackson, concurring. The Federal Unemployment Tax Act, FUTA, allows a state to exempt from its unemployment coverage mandate any organization which is operated primarily for religious purposes and which is operated, supervised, controlled, or principally supported by a church or convention or association of churches. Like many states, Wisconsin enacted a religious purposes exemption that tracks Section 3309b, 1b. As the court explains, the Wisconsin Supreme Court's application of that exemption has created a constitutional problem. The state treats church-affiliated charities that proselytize and serve co-religionists exclusively differently from those that do not. Because I agree that this distinction violates the neutrality principle of the Constitution's religion clauses, I join the court's opinion in full. I write separately because, in my view, FUTA's religious purposes exemption does not distinguish between charitable organizations based on their engagement in proselytization or their service to religious adherents, nor does that exemption differentiate based on religious motivation, as the government insists. Rather, both the text and legislative history of FUTA's religious purposes exemption confirm that Congress used the phrase operated primarily for religious purposes to refer to the organization's function, not its inspiration. Put differently, Section 3309b, 1b, turns on what an entity does, not how or why it does it. America constructed its unemployment insurance system during the Great Depression to mitigate the disruptive effects of sudden job loss on workers. Wisconsin led the way in 1932, after identifying unemployment as an urgent public problem. Wisconsin Stat. Section 108.011. Congress followed suit later that same decade by enacting FUTA, which called for a cooperative federal-state program of benefits to unemployed workers, as noted in St. Martin Evangelical Lutheran Church v. South Dakota. FUTA operates by setting a federal minimum level of unemployment coverage that state programs must provide to remain eligible for certain grants and tax incentives. To obtain federal approval, states must mandate participation by at least those categories of employers that federal law requires to be covered. FUTA also allows, but does not compel, states to exempt specific categories of employers from mandatory participation. Before 1970, FUTA allowed states to exempt nearly all nonprofit employers from unemployment coverage. But in 1970, Congress reversed course and required the opposite, that state unemployment insurance programs cover most nonprofit workers. In the Employment Security Amendments of 1970, Congress addressed this raising of the unemployment coverage floor, with the House Ways and Means Committee finding that, with respect to nonprofit organizations, unemployment affects a substantial number of their employees, particularly people working in non-professional occupations. FUTA's inclusion of nonprofits addressed Congress's concerns about the need of their employees for protection against wage loss resulting from unemployment. The 1970 amendments further specified certain new and narrower categories of permissible nonprofit exemptions, as described in St. Martin. One was the religious purposes provision at issue here. Per the statute's language, which Wisconsin subsequently adopted, a state can choose to exempt from its unemployment insurance mandate an organization which is operated primarily for religious purposes and which is operated, supervised, controlled, or principally supported by a church or convention or association of churches. This case arises out of a dispute about the meaning of the phrase operated primarily for religious purposes in Wisconsin Stat. Section 108.0215H2, which tracks Section 3309B, 1b. When the Wisconsin Supreme Court affirmed the denial of petitioner's exemption request, it concluded that this clause requires judicial inquiry into both the motivations and the activities of the organization. With respect to activities, the court examined how Catholic Charities and its sub-entities provided their charitable services, and in particular, whether they did so while attempting to imbue program participants with the Catholic faith, or supplying any religious materials to program participants or employees. It also observed that both employment with the organizations and services offered by the organizations are open to all participants regardless of religion. The court further suggested that a church-affiliated charity would likely obtain the exemption if it engaged in teaching, evangelism, and worship, but not otherwise. The government urges us to hold that FUDA's use of the phrase operated primarily for religious purposes refers only to why the organization is engaging in the charitable work at issue, i.e., the motivations that drive the organization to conduct its activities. It argues that, in the context of an individual, the word purposes most naturally refers to the mental state accompanying their activities. So, the government contends, a charity's eligibility for the exemption must turn on its underlying motives. In my view, however, neither Wisconsin's motivations plus activities reading, the how, nor the government's motivations only interpretation, the why, accurately captures what Congress intended when it devised Section 3309B, 1b, to allow an exemption for church-affiliated entities that are operated primarily for religious purposes. I think, instead, that Section 3309B, 1b, relates solely to what the entity does. I reached that conclusion first by examining the text of the provision and then by consulting the statute's established enactment history. These sources clarify that the religious purposes exemption is not applicable to general charitable organizations, for example, soup kitchens, hospitals, or orphanages. Rather, Congress designed the exemption to capture a much narrower category of employers, church-affiliated entities that exist to perform religious functions. Start with the text. To fall within Section 3309B, 1b's exemption, an employer must satisfy two requirements. First, it must be operated primarily for religious purposes. Second, it must be operated, supervised, controlled, or principally supported by a church or convention or association of churches. Here, no one disputes that the Catholic Church operates, supervises, controls, or principally supports the charities at issue. The fight is over whether church-affiliated charitable organizations, sub-entities that primarily provide job training, mental health, and other services to those with developmental disabilities, along with the entity that oversees these and other charities, satisfy the first requirement, that is, whether they operate primarily for religious purposes within the meaning of this provision. Notably, the language of the provision only goes so far, because Section 3309B, 1b, does not define the term religious purposes, and purposes admits of several possible meanings. When used in certain contexts, such as on purpose, the term can refer to one's intent, but it can also mean an end or aim to be kept in view in any plan, measure, exertion, or operation. Another way of conceptualizing this second definition is, the object which one has in view or the object for which anything is done or made, or for which it exists. This accords with common usage of the term. If something is put to no good purpose, then it is not performing any effective function. The government does not dispute that purposes can refer to ends, but it views ends as relating solely to an organization's fundamental motivation for its affairs, not the nature of its activities. The government does not explain how it makes this logical leap, from the entity's end, i.e., the object it exists to achieve, to the entity's motivation, i.e., its inspiration for seeking that achievement. In my view, the only way to close the gap is to try to ascertain Congress's intent. That is, because religious purposes is susceptible to more than one reading in this context, it could mean either what an entity does or why it does it. An interpreter of this provision must ask, which reading did Congress intend when it inserted that phrase into this statute? The text of Section 3309B, 1b, itself provides a clue. If one reads operated primarily for religious purposes to track an organization's motivation, rather than its function, the provision becomes almost entirely superfluous. Recall that, To be exempt under Section 3309b, 1b, the organization must be operated, supervised, controlled, or principally supported by a church or convention or association of churches. And, of course, every church has religious motives for its activities. Thus, Prong 2 of Section 3309b, 1b, already establishes religious motivation. The charitable entity is, after all, run by or otherwise closely affiliated with a church, leaving Prong 1 with no additional work to do if it, too, is interpreted as a religious motive element. While not dispositive, this superfluidity problem weighs in favor of a construction of operated primarily for religious purposes that looks to what an entity does rather than its motives. In TRW Incorporated v. Andrews, we noted that a statute ought, upon the whole, to be so construed that, if it can be prevented, no clause, sentence, or word shall be superfluous, void, or insignificant. The functional understanding of operated primarily for religious purposes also makes perfect sense. So interpreted, it addresses a different factor than Prong 2 because it gets at what the church-run entity actually does. Workforce programs train workers. Hospitals care for the sick. Soup kitchens feed the hungry. Shelters house the homeless. That said, I admit that Section 3309b, 1b's text alone may not provide a dispositive answer, and thus requires further exploration. For that reason, I look to the provision's enactment history. In American Broadcasting Co.'s v. Aereo Incorporated, we turn to legislative history when text is ambiguous, and in Delaware v. Pennsylvania, we noted that clear evidence of congressional intent may illuminate ambiguous text. In the House and Senate reports accompanying the 1970 FUTA amendments, Congress signaled that it designed the Section 3309b, 1b, exemption to distinguish between church-related organizations performing ministerial functions, which it wanted to allow states to exempt, and those performing general charitable functions, which it wanted to require states to cover. This makes clear that what the entity does matters for purposes of applying the exemption. To explain this, Congress included a series of examples distinguishing the kinds of church-run entities it thought were exemptable. On the exempt side of the line, the reports list 1. A college devoted primarily to preparing students for the ministry, 2. A novitiate, and 3. A house of study training candidates to become members of religious orders. On the non-exempt side of the line, the reports state that a church-related, separately incorporated, charitable organization, such as, for example, an orphanage or a home for the aged, would not be considered under this paragraph to be operated primarily for religious purposes. Nowhere does Congress mention how, much less why, these paradigmatic entities go about their work. These examples are instructive. The exempt category as the reports defined it lists solely church-run nonprofits that have service to the church itself as their main objective. A novitiate, for instance, is an entity that trains and houses novices who are deciding whether to pursue a life in a religious order or priesthood. Indeed, what unites all three exempt entities is what they do: preparing people for religious life and for service to the church, i.e., they all serve religious functions. By contrast, the non-exempt category consists of general charitable organizations affiliated with the church. A church-related orphanage or home for the aged is not operated primarily for religious purposes, at least within the meaning Congress intended that phrase to carry. Through the report's examples, Congress thus clarified that it does not matter how or why the entity goes about its work. All that matters is what it does. As such, orphanages, nursing homes, and charities like them, i.e., entities whose purpose is to care for children or tend to the elderly, do not exhibit what Congress considered to be religious purposes under this exemption. And that is true regardless of whether religion motivates the entity's work. This function-based reading of operated primarily for religious purposes not only follows from the text and legislative history of Section 3309b, 1b, it also best accords with the anti-entanglement justification for the religious purposes exemption. Wisconsin maintains that it adopted its state version of Section 3309b, 1b, to keep the government out of unemployment eligibility adjudications that implicate questions of church doctrine. But a reading of the exemption that requires assessment of the entity's motivations, instead of its actual work, does little to further that anti-entanglement objective. Consider the state unemployment insurance scheme at issue here. Unemployed workers are not automatically eligible to receive unemployment benefits. Those who have been terminated for misconduct, for example, may be ineligible. Employers can therefore object to any worker's unemployment claim on misconduct grounds. When that happens, the state's unemployment agency must then decide whether to deny benefits by considering the circumstances of the unemployment benefit applicant's discharge. For certain church-related employers, for example, novitiates, houses of study, and colleges that train ministers, that assessment might entangle the state in employment disputes that turn on religious faith and doctrine. Imagine, for example, the adjudication of disputes over the sufficiency of a fired employee's prayers or the accuracy of their scriptural teaching. Indeed, it is precisely because of what novitiates, houses of religious study, and ministerial training colleges do, prepare individuals for religious life, that potential entanglement problems occur. By contrast, when a church-run entity provides general charitable services to the public, the same kinds of entanglement issues are far less likely to arise. What is more, a motive-focused exemption inquiry presents potential entanglement problems of its own. If taken seriously as an eligibility requirement, as opposed to a rubber stamp for any organization that professes religious motives, it would require assessing whether an entity is really motivated primarily by religion, an intrusive exploration into the hearts and minds of those who run it. Requiring courts to engage in the business of evaluating religious motivation is a sensitive endeavor. And here, it is unnecessary, because the church affiliation prong already does that work. It actually serves no rational objective, as the sincerity of an entity's religious motives has little if anything to do with the problem Congress sought to address. Church-related nonprofit employers care for the sick, feed the hungry, and improve the world in countless ways. Most do this, no doubt, for religious reasons. All do this thanks to their employees' labor. As I read Section 3309b, 1b, evaluating whether a church-affiliated nonprofit operates primarily for religious purposes is not a matter of assessing the sincerity or primacy of its religious motives. Instead, as with so many other interpretive issues, determining what the religious purposes exemption means involves attempting to discern what Congress was trying to achieve. Here, Congress sought to extend to most nonprofit workers the stability that unemployment insurance offers, while exempting a narrow category of church-affiliated entities most likely to cause significant entanglement problems for the unemployment system, precisely because their work involves preparing individuals for religious life. It is perfectly consistent with the opinion the court hands down today for states to align their Section 3309b, 1b, based religious purposes exemptions with Congress's true focus. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.